Hello, everybody. Welcome to the Jim Thompson House and to our intellectual property talk today. My name is Chomwan. I think everyone knows me here, though. But I'd like to introduce Professor David Llewelyn. David was my professor throughout university and during my research years, and is a world-renowned intellectual property specialist. We have the great pleasure of having him today with us to be able to talk about how to play the intellectual property game. David recently founded a new law firm based in Singapore called Acton Law, a boutique law firm specializing in IP and everything else. He is also a professor at King's College London, which is where I went, at SMU in Singapore, and also an honorary professor at the University of Hong Kong, as well as having authored a book called Invisible Gold in Asia. It talks about creating value from intellectual property in Asia, and I think that's something that's really kind of important today, and probably why many of us are here, to be able to see how, this sometimes seemingly cryptic thing, IP, could be of use to all of us. And he's also written a bunch of other books, but I'm going to hand this over to David. I think he's going to be speaking in English, a gathering from everyone in the room. I think that should be okay. If there's any question, it'll be a Q&A session at the end, bilingual, of course. I'm happy to translate anything, everything. ยินดีต้อนรับทุกคนค่ะขอบคุณที่มายังไงเดี๋ยวดู pass over ให้อาจารย์ David Llewelyn. Thanks.
Thank you, John Wan. I much prefer standing up, because at least then I feel as if I'm doing something, whereas if I sit down, I just feel I'm not really doing anything. Thank you very much for coming along today on this holiday. I said to John Wan, I was coming up to Bangkok, should I give a talk? And she said, yes, but it's a holiday. So I'm very pleased to see that there are some people here, despite the fact that it's a holiday, and thank you very much for coming along. What I want to spend the next 45 minutes or so doing is to try and explain I think probably you can hear me without this, but what I want to try and do is explain the positive side of intellectual property, because too many people, when they hear the words intellectual property, they think counterfeiting, piracy. They think about the bad side of intellectual property, whereas intellectual property can be a very valuable thing for businesses, for people in creating their own intellectual property and creating value because they know how the game works. And I'm not going to pretend that this is a game that everybody can play. Am I? Perhaps everybody can play it, but there are some teams who are like Real Madrid, and there are some teams who are like Liverpool goalkeepers, who will let in goals even when they shouldn't. So I just want to describe really first of all, some of the common misconceptions, the misunderstandings about intellectual property, because it's now something which is so all-pervasive. It's everywhere. Yet when people talk about intellectual property, they very rarely understand what they're talking about. Each person has a different view about what intellectual property is. And so what I want to do is, first of all, mention 10 myths. 10 no, that's not true, but things which people seem to think. And the first of those myths is intellectual property equals patents. That's not true. In many industries, patents are irrelevant. In many businesses, patents are completely pointless. But in the newspapers, in the media, you will see this company bought patents, this company, Apple sued Samsung. This last week, $600 million in damages awarded against Samsung in a court in California for Apple. So for some people, patents are intellectual property. But it depends what industry you're in as to what is intellectual property. Because if you're in the pharmaceutical industry, patents can be very important. If you're in the software industry, patents can be very important in the United States. But in most of the other countries, it's not important because it's very difficult to get patents covering software except in the United States. And that's an important point as well. One has to remember that intellectual property is different in every country of the world. There is no such thing. There is no international intellectual property rights. You have an intellectual property right in Thailand, you have an intellectual property right in Singapore, you have an intellectual property right in Malaysia. And you have to look at the law of each country to decide whether you have a right to stop somebody else from doing something or not. So these are national rights. But it's not quite as bad as that makes it sound. But IP is very, very broad. It covers copyright. It covers brands. You know, obviously here in Jim Thompson House, Jim Thompson, a Thai brand. So it covers trademarks, it covers trade names, it covers patents, it covers copyright, it covers even plants and seeds. Charan Pokwand, CP Group, is one of the big owners of plant patents because they get new varieties of rice, for example, new plants, and they get patent protection for them in many countries around the world. And then they license those. They give people permission to grow them because they have plant patents. So intellectual property is a very, very broad area. So it depends on what you're looking at before you need to decide what are the relevant intellectual property rights. So that's the first point, is intellectual property is a very, very broad area. The next point is having intellectual property rights in Singapore, which is where I live, or in Thailand, is usually not enough. So for example, often people will get a trademark in their home country. And they don't think, where am I going to do business tomorrow, next week, next month, next year? Because you need to think, do I want to get a trademark there as well? So for example, there's a Singapore company called Bread Talk, which has a chain of stores selling bakery products. They didn't think ahead. So when they moved into China, they found that a local Chinese company had registered Bread Talk as a trademark in the People's Republic of China. So what did they have to do? They had to go and buy from the Chinese company the trademark that was really theirs, because it was less expensive to buy it than it was to sue them and go to court. So you need to think ahead as to where you are going to be doing business, where you might be expanding your goodwill. So having IPRs in your home country is not enough. You've got to think, where are you going to be selling? Where are you going to be manufacturing? Where might you be able to license? What's a license? All that a license is a permission to do something that would otherwise be an infringement of a right. It's like a lease. If I have an apartment and I allow somebody to live in my apartment as a tenant, then I'm giving them a permission to trespass, effectively, to come into my apartment and live there. With intellectual property rights, giving a license to somebody is the same. I give you the permission to use my intellectual property rights, and you pay me for that permission. That's all that a license is. But it's very important in this area. So you've got to think internationally here, unless you're just going to stay in a small area. So if you have a restaurant and you only have one restaurant and you don't want to have another restaurant, then fine. Obtain a trademark for the name of your restaurant. But if you think you want to franchise it, you want to go to other parts of the country, then you should think ahead about where are you going to expand. So again, in Singapore, Crystal Jade is a restaurant. Started with one, now in Singapore there are 10, and there are also Crystal Jades in Seoul, in Hong Kong, in Macau, in Beijing, and they have registered trademarks in all those places so that they can stop other people from opening something which is confusing with Crystal Jade. So having IPRs just in your home country is usually not enough. So that's the second misconception, the second myth, that having IPRs here is enough. I mean, I remember often when I was practicing as a lawyer in London, Americans would come to me and they would say, somebody is infringing my rights. And I would say, where? And they'd say, in Shanghai. And I would say, well, have you got a registered trademark or have you got a patent in China? They say, no, I've got one here. It's from the US Patent and Trademark Office. And I'd say, but that's no good. That's only important in the United States. It's of no importance in China. And so you've got to be thinking about the fact that these are national rights. That's a disadvantage, but it can be an advantage as well. And I'll come back to how that can be an advantage later. So that's the second myth. The third myth is that intellectual property rights restrict the flow of ideas. This is something that a lot of people say, oh, ideas are stopped because of intellectual property rights. This is not true. Because intellectual property rights do not protect ideas as such. So, for example, the patent. A patent can only be obtained for a new product or process. So it has to be for a new product or a new process. A trademark is an indication of trade origin. It's an indication of who is responsible for these products. A copyright protects an expression of an idea. So there's been some discussion recently about, can you protect the recipes for well-known food products? And the answer is no, you can't. Because if I write down a recipe and somebody makes a dish from that recipe, they are not copying the expression of the idea. They are taking the ideas, and you're allowed to do that. You couldn't copy the piece of paper on which the recipe is written without permission from the copyright owner, but copyright does not protect an idea. It only protects the way that it's written down. So if I am a young, unmarried mother who is very interested in little schoolboys and magic, and I write, sitting in a cafe in Edinburgh in Scotland, I write a book about a boy who's fascinated by magic, and that I sell the copyright in that to a publisher, and it becomes Harry Potter, then that does not allow me to stop everybody else from writing books about boys who are interested in magic. Of course, Bloomsbury Publishing, Universal Pictures, they have Harry Potter registered for a lot of different things as a trademark. So if you want to use Harry Potter on products, you may find you will be sued. But that's a trademark issue. It's not a copyright issue. So you've got to remember the different nature of some of these rights. So intellectual property rights do not restrict the flow of ideas. Usually what restricts the flow of ideas is contract. Because if you, for example, have a subscription to a database, what you can do with that database will be affected by the contract that you enter into. In the same way as when you join Facebook. When you join Facebook and you say, I agree, you are agreeing to give a license to Facebook to use all your intellectual property. When you join WhatsApp, and tick, I agree, you are agreeing to a license to Instagram, to WhatsApp, for your intellectual property rights. And that's a contract. Because when you press I agree, there is a contract entered into, usually a contract which is governed by the law of Massachusetts, the law of California, and any dispute under that contract will be heard in Massachusetts or California. So when you press I agree, even if it means when you play an online game, sometime you should read the contract and you will be very surprised what you have agreed to. You have agreed to transfer or to license intellectual property rights as part of that contract. Okay, the next misconception about intellectual property, all you need to do is copy the United States. Not true. The United States, in my view, there are two intellectual property worlds. The first intellectual property world is the United States. The second intellectual property world is the rest of the world. Because in the United States, there are intellectual property disputes every day. There is a legal system that encourages those disputes, because I can go to a lawyer in the United States and say, will you take my case? And if you take my case, I will give you 60% of anything that you get. So, for example, Mark Zuckerberg. When Mark Zuckerberg was at Harvard, and two of his college mates, called Winklevoss, came up with the idea of a social network. They came to Zuckerberg and said, will you do the coding? We think this is a good idea. Zuckerberg realized this was a good idea quite early on, and he ended that arrangement with the Winklevoss twins. Then Facebook came up. First of all, it was the Facebook. And then he removed the. So it's now Facebook. And more money came into Facebook. And whenever there's money in the United States, there is litigation. There are court cases. And the Winklevoss two brothers, twins, they sued Zuckerberg because they said that Zuckerberg had stolen their intellectual property, because they went to him with the idea and then he realized it was a good idea and he did it himself. In the end, the case was settled and Zuckerberg paid the Winklevoss twins $65 million to go away. How do we know this? Because the Winklevoss twins used a law firm called Quinn Emanuel, and the Winklevoss twins said, look, Facebook has become even more valuable than we thought it was going to be. You should not have told us to settle this case for only $65 million. We're not paying you. So the law firm had to sue the Winklevoss twins to get their 60% of the settlement, $65 million, and they won. So this all came out in court. Now, of course, the Winklevoss twins are the first Bitcoin billionaires because they invested some of the money that they won in that case early on in Bitcoin, and now they are apparently Bitcoin billionaires. But the importance of that is that in the US, there are law firms who will take your case, and it costs you no money, but they will take 60% of anything that they manage to get. In many countries of the world, you are not allowed to do that. In Singapore, you are not allowed to do that. In England, you're not allowed to do that, because the lawyers say that this provides a conflict of interest. But it does mean there is a lot of litigation in the US. There is also the fact that in the United States, there are so-called treble damages. Whereas in Thailand and other countries, if you win when you sue somebody, you just get your damage. In the United States, you can get 3 times the damage. That's the reason for these $1 billion headline in the media, because it's treble damages. And the other point is that in the United States, unlike Thailand, unlike anywhere else in the world, juries decide liability in intellectual property infringement cases. So you have 12 people who know nothing about intellectual property deciding whether something is or is not an infringement of an intellectual property right. And often they will be sympathetic to the small guy. But it depends on where in the United States. In Texas, often they decide in favor of the big corporation. In some other places, perhaps less so. So copy the US. Often you will make big errors if you think that Asia is like the United States. It's not. Both in terms of the infringement of intellectual property rights and also in how relatively easy it is to sue people. There's no point in suing people in India. It will take you 100 years to get to court. Not quite, but almost. So litigation is not the big thing in India that it is in the United States. Or in Japan, it's quite efficient, but you need to be careful where to sue. So copying the USA is not what other countries should do. But there is, in this part of the world, a view, well, the United States did this, therefore we should do it. I think that's wrong, and it's an attitude of mind that is now changing because of the way that the PRC is pushing back on a lot of these things, and the PRC is now trying to play the IP game, and unfortunately, very effectively. So we're seeing now changes in the attitudes to intellectual property. The next no, it's not true, is getting the intellectual property rights is the hard part. It's not. That's the easy part. Knowing why you want intellectual property rights and what you can do with them is another thing. Because, for example, Thomas Edison, he described a patent as an invitation to a lawsuit. That's all it is. It's a liability because you have to sue people if they infringe it. Why do you want these intellectual property rights is a very important question to ask yourself. Because many people say, I've got intellectual property rights. And the next question that you should ask them is, and what do you want to do with them? Why have you got them? Because there are many businesses who waste money obtaining intellectual property rights. Why do they waste it? Because they don't know why they're getting them. And the important point is that these are different rights, as I said. Some you can get easily. Copyright, you get automatically. A patent you have to apply for. It's expensive. A trademark you have to apply for. It's quite expensive. The more goods or services that you want it to be registered for, the more expensive it is. So some are very inexpensive. So copyright arises automatically when you create something in writing, or it's a painting, you own copyright in it. And you also have copyright in it in practically every country of the world. So even though you might create a design in Thailand, you will automatically own copyright in that design in practically every country of the world under international conventions. But that comes with difficulties, because it means that you have to look at US law to decide what is an infringement of your design in the US. It may be different to what is an infringement of your design in Thailand, or what is an infringement of the same design in the People's Republic of China. So you have to really think about, why do you want intellectual property rights? Which intellectual property rights? The trademarks, the brands, very important, especially with online business. Because if you can create your own brand that you can register as a trademark, you can obtain domain names for, you're starting to create authenticity. You're starting to create goodwill in your name. So trademarks, very important. Copyright, very important, because it costs nothing to obtain copyright, as long as you know what you then are going to do with it. And we can come back and look at that. So that's a misconception, is getting the IPRs is the hard part. It's not. It's the easy part. The hard part is to know why you want intellectual property rights and what you are going to do with them. How are you going to play the game? The next is they can wait. Some can, some cannot. So if you come up with a novel product or a novel process, it can't wait. You have to apply for it before you put the product on the market. Because once the product is on the market, it is no longer new. So with patents, they can't wait. You get one chance to apply for a patent, and that is before you put the product on the market. Even Nespresso made that mistake. Nespresso, the subsidiary company of Nestle, they had a new idea for how to put the pods into a coffee machine. And they wanted to apply for a patent so that other people could not make pods which could be put into their Nespresso machines. They sent some machines to 20 people to try them out. And they then applied for the patent. They didn't get the patent because by giving those 20 machines to those people, it was no longer new when the application was made. They should have given them under a non-disclosure agreement, because then that disclosure would not make the product, would not defeat the product's novelty. So some intellectual property rights can wait. You can wait before applying for a trademark. You do not have to obtain a registered trademark. In most countries of the world, just by selling a product under a name, you are creating some rights. Unfair competition or passing off type of rights. So you can apply for a registered trademark later. You do not have to apply for a trademark. Copyright, as I say, you have it automatically. There are some things you can do. Put a little C in a circle and your name and the year. It's irrelevant from a legal point of view, but it makes other people think you know how to play the game. So put a little C in a circle beside your designs, because other people then think you understand the game. it used to be that in the United States, if you didn't put a copyright symbol, then you would get lower damages. But now, as long as you apply, well, it's quite complicated in the US, but there is no significance any longer to putting the C in a circle. You do not have to put the C in a circle and the year in order to have copyright. But if you do, it makes people think that you know how to play the game. Same as TM. Put a little TM beside the product name, even though you don't have a registered trademark. Because people who don't understand it think you've got a trademark. And if what you're trying to do is create this impression that you understand how to play the IP game. Because people who are going to copy have a number of things that they could copy. And if they think that you know how to play this game, they might not copy yours. So put a little TM beside it. Do not put an R in a circle, because that is a criminal offense in most countries. If you haven't got a registered trademark, to use an R in a circle is a criminal offense. So don't do that if you haven't got a registered trademark. Just put a little TM beside your strap line. So for example, Kentucky Fried Chicken. They had finger licking good. And they would always put a little TM beside it when they used it in advertising. And then later they applied for a registered trademark. Or We Try Harder, Avis or Hertz, I can't remember which. Put a little TM beside it. So that in all your advertising or your promotional literature, because then people think you know what you're talking about. You're also building goodwill in these names, and people will look at that as being part of your invisible gold, as I've described it in one of the books that Chomwan mentioned. So just play all these games. It costs nothing, but it just shows that you are aware that this is a game, and you're playing by the particular rules. The next misconception: IPRs are expensive and only for big business. That is not true either. Some intellectual property rights are expensive. As I've just described, some are inexpensive or cost less, such as copyright. Patents, certainly expensive. I always used to say when advising large clients, do not budget on less than 20,000 US per country for a relatively simple patent. But this is for an innovation patent, not for a design patent. And you have to remember that some countries have design patents, like China, like the US. The Samsung Apple case is mostly about design. The design of the iPhone, the design of the icon. It's not about innovation, it's about design. China, you've got design patents as well. But when I talk about patents generally, I'm talking about innovation patents. So some IPRs are expensive, some are not. And they certainly are not only for big business. It's very interesting when you look at some big businesses, they started by being copiers. You look at Apple. When Apple was set up by Steve Wozniak and Steve Jobs in the 1970s, the first thing that happened was they received a writ from the Beatles record company, which was called Apple Records. And Apple Records said, you can't use Apple for your computer company. And they said, well, okay, we'll stay in computers, you stay in music. Now, of course, they didn't think ahead. So that 10 years ago, when the iPlayer, or 8 years ago, when the iPlayer started, Apple Records said, you're breaching this agreement. You are now in music. You agreed to stay out of music. You said you would stay in computers. So they had to do a deal, and that's why Beatles is now on iTunes, whereas before that, the Beatles were not on iTunes. So they did a special deal so that the Beatles record company gets paid a higher royalty for Beatles downloads compared to other ones. So Apple was a copier. Whenever Apple come up with a new product, they hardly ever have innovated that product. You look at the tablet, you look at the iPad. The iPad had already, the tablet computer had already been developed by Taiwanese companies in 2000, 2003, even before Steve Jobs had thought about it. But his genius was design, designing the beautiful look of it, the packaging, everything else. So they're actually not an innovative company, Apple. They are a brilliant design company. Or you look at Lego. Lego, a very successful company, but it started as a copier. Mr. Christensen, who is a Danish man, he was visited by a toy salesman who had a very clever system for fitting wooden bricks together. And he thought, that's a good idea. He had just bought a plastic extrusion machine, and he didn't know what to do with it. So he thought, I will make these bricks with plastic, highly colored plastic. He thought, I need a trademark. And he came up with a very good trademark from the Danish for play well, which is leg godt. So Lego was his trademark, and he registered his trademark, Lego. He started to make these products because he realized that the person who had visited him had a patent for this connection, but only in England, nowhere else. So he made these products in Denmark, no problem. He sold them everywhere except for England until the patent expired. Patents are for maximum then 16 years, now 20 years maximum. After that, you can make the product yourself without paying anything. So, and now Lego have lots of patents, they have lots of trademarks, they sue everybody who makes anything that can fit with Lego. Sometimes they win, sometimes they lose. But all these people started as copiers, or the Body Shop. Body Shop was a company set up by two British people, Anita and Gordon Roddick. They visited California in the late 1960s, and they saw some cosmetics which were tested without animal testing. And they thought, this is good, cucumber and all these things. So they took a list of these products, went back to England, they registered the trademark Body Shop, they copied the products, because the hippies in California had done nothing. They'd got no trademarks, they'd got no protection, and so the Body Shopper eventually was sold to L'Oreal for $600 million US. And it started basically by copying a business in California which had not protected itself outside California and then spread around the world. Later, Body Shop went back to talk to those two Californians, and they took a transfer of all or any rights that the Californians had under a non-disclosure agreement. And they paid them a bit of money so that they would never say, these people copied us. So that's what Lego did as well. They went to the English person's family after he died with no money, and they said, transfer to us all or any rights that the late inventor had under a non-disclosure agreement. So you're not allowed to say that Lego started as a copyist. So one always needs to remember that this is all about spinning. It's all about how do you write the story about what you're trying to create. How do you actually position yourself as an innovative or a design company? So it's not only for big business. If you start off in the right way, you can then grow this. IP infringement is theft. This is a favorite statement of the US government. It is nonsense. Because as a lawyer, unfortunately, I look at words and read them as they should be, not as politicians say they are. And theft is taking property belonging to another with the intention of permanently depriving the other of it. Intellectual property infringement is not theft because it is not taking property from somebody else. The somebody else still has it. What it is trespass. It is like somebody walking across your garden when you didn't give them the permission to do so. It is not theft. It's a very good headline for policymakers to say, IP theft loses America billions every year. IP infringements may lose America billions a year, but IP infringement is not theft. It's a very good writing of the narrative because whoever speaks in favor of thieves. The minute you say it's theft, nobody will justify it. But Apple, Lego, Body Shop, on this analysis, all started as thieves. And now, they are among the most respected companies in the world. So it depends on your perspective. You have to be very careful about throwing around some of these terms. The next myth, all IPRs are the same. They are not. For example, brands, trademarks. If you get a registered trademark, it can last for a very long time. In the UK, in England, registered trademark number 1 is the red triangle for beer. That was registered in 1873. Trademarks you have to re-register every 10 years. In most countries, some countries 7 years. And as long as they don't become generic, you can continue to have protection for registered trademarks. So escalator. Escalator was a registered trademark belonging to the Otis elevator company. But because it became the way of describing a moving staircase, they lost the registered trademark. There are other examples of that. So you need to be careful. I think Google has a problem, because when you say, I'll go and Google that, do you mean you will use Google, or do you mean you will use a search engine? Or Coke. That's why Coca-Cola often have advertising. Coca-Cola is Coke, and Coke is Coca-Cola. And both are registered trademarks belonging to the Coca-Cola Company of Atlanta, Georgia. Because they are afraid that you lose Coke as a trademark. Because when people order a rum and Coke, do they mean a rum and cola? Or do they mean a rum and the cola that is made by the Coca-Cola Company? So trademarks that can last a very long time. Copyright lasts a long time. Generally, copyright lasts for the life of the author plus 50 or 70 years, depending on the country. A long time, without registration. A patent, as I said, between 16 and 20 years maximum. Design patents, 20 years or 25 years. So they last for different periods. Also, they are different. A patent is a monopoly. So if somebody does something which falls within your patent, they infringe, even if they do not know about your patent. But with copyright, it is what it says it is. It is a right to stop copying. So that if somebody else creates the same copyright work without looking at yours, it is not a copyright infringement. It is not a monopoly. So if two people sit together looking at some view and they both draw that view, they both own copyright in their works. Unless one of them is looking at the person next to them and copying what they're doing. That would be copyright infringement. So copyright is what it says it is, a right to stop copying. But remember there, very important, it's a right to stop copying. The government is not going to do it for you. These are private rights. You have to enforce these rights. Nobody else is going to do it for you. And this is where a very important issue arises, which is cooperation, collaboration, working with other people. And I'll come back to that in a minute. And all registered IPRs are valid? Not necessarily. There are many registered trademarks, there are many patents which are registered but should not be. But in order to challenge them, you have to spend money. So obtaining an invalid right is often very valuable because people won't challenge it if it's been granted. So, the challenge in this area is to make IP an integral part of your growing business. To think about it always. How do I mark little TM? How do I put a little C in a circle? When do I apply for a registered trademark? Where? So have somebody who owns the IPR portfolio, who understands the game. Because often people complain and they find that they made silly mistakes early on. Whereas if you have somebody who looks after this, it suggests to outside people, to potential investors, that you know what you're doing. And a lot of this is about perception rather than reality. Short-term versus long-term. This is a big issue with intellectual property rights in this area, in this region. Often businesses would prefer the short-term return rather than the long-term investment in intellectual property, which often will result in a longer-term sustainable business. They'd prefer to get money quickly now. But that's not to say that it's always correct to turn down the short-term money. Sometimes it's very important. Think ahead. Comes back to what I said, someone who owns the IPR portfolio. Think about where you're going to expand. Think about where potential licensees are. Don't just react when you've got a problem. Because if you react when you have a problem, it will be far more expensive than if you anticipate what you're going to do. And develop an IPR strategy and keep to it. Bear in mind who's doing the work. Lack of clarity about ownership. With designs, for example, you must remember the difference between employees and independent contractors. Where an employee creates a design, it belongs automatically in most countries of the world to the employer. So the designer who created what is today Hello Kitty and that horrible cat, he was an employee of Sanrio. So therefore Sanrio obtained over $1 billion in licensing fees of Hello Kitty, even though it was created by an employee. Whereas if he had been an independent contractor, it would belong to the independent contractor unless there was an assignment of the copyright in writing. So one's got to think about the contractual relationship. The other problem that I often have, because I have a small IP investment company, is unrealistic valuation of intellectual property. Some people, they think I'm brilliant. I've got fantastic intellectual property. I want you to invest. Well, how much is your intellectual property worth? And they say a fortune. Look, the potential market is huge. And I say, yes, but it's the potential market that is huge. How are you going to exploit that market without somebody's help? And so often unrealistic valuation of intellectual property prevents its exploitation properly. This is just the importance of an IP-friendly culture for small and medium-sized enterprises. Go out and talk to incubators. Find mentors who understand this game. Also education and specialist courts. So if you decide to play the IP game and you get intellectual property rights or an intellectual property right, what can you do with it? Well, the first is you can hang it on the wall if it's registered. And I know many inventors who love to do this. They apply for patents. They get a patent certificate. They never do anything with it. They hang the certificate on their wall and say, I am clever. Which is fine if that's what your interest is, but it may not be particularly fruitful. Then exercise it, exploit it yourself. Or you could sell it, assign it, transfer it, all means the same thing legally. You could sell it to somebody else. And there are many designers, there are many businesses which are very good at creation, but they're not good at marketing. They're not good at getting products on the market. So they can sell and then move on to the next one. And that's a perfectly legitimate and very useful way of doing what you're good at and avoiding what you're not good at. Or you can license it to somebody else. You can decide, okay, I'm going to use it in Thailand, and I will license my trademark and my copyright and my know-how, my trade secrets to somebody to make a product in China. And then you have to work out, do I want the money up front because they're never going to pay me in future? I'll take some money then and the rest of the money later in terms of royalties. Or you could do a joint venture. And what you always need to remember is if at first you don't succeed, and this is the Razr example from Singapore, the Razr boomslang mouse. This was a very interesting company which was started as long ago as 1998, and it failed 2 years later. The people behind it went and bought all the rights from the insolvency practitioners. And they tried again. And so they started again in 2005. 12 years later, they floated the company in the Hong Kong Stock Exchange, and the founder, Tan Min Yang, was apparently quoted as being worth US $1.3 billion. I think that's now about 900 billion because their share price has gone down recently. But it shows that he tried again. He did it with different people. It was the same technology, probably in 1998, ahead of its time. Whereas in 2005, 2010, the rest of the market had caught up. And also in this area, you should not reinvent the wheel. Because if some other people have done something already, it is often better to take a license from them and pay a small royalty to use their invention, for example, rather than trying to do it yourself. And Sony is the best example of that, where Sony was based on a license from the US, and they built the whole of their transistor business on the back of that. But the important point here, I think, the most important point, don't try to do everything yourself. Because I often find people think, this is great, and they want to keep it to themselves because they're afraid of talking to anybody about it because they'll have it stolen. But actually, if you keep it to yourself, it's not going to do anything. So you have to cooperate with other people. But you should be proactive, not just reactive. And do your due diligence. Do your checking. Do not just go put your head in a lion's mouth. Find out whether the lion has already eaten before you do that. You must do your checking of who you go into partnership with. who you take as your investors. Are they trustworthy? Are they not? Too often people come to me and say, oh, I've been ripped off by these people. And I do some checking, and I find they do that all the time. Why didn't they find out before they entered into the deal? And remember that 2 and 2 often equals more than 4. If you're good at design and somebody else is good at marketing and somebody else is good at selling, then do what you're good at. Also, you may know the market, they may not. Or they may, and you may not. And so finally, I want to give you my best example of that, which is a tie example, which shows that 49% of a lot is much better than 100% of nothing. And that was the Thai gentleman on the top right-hand corner who did a deal with Dietrich Mateschitz. What was it? You all know what it was. It was Kreting Deng. Oh, is it? Yeah. And because Mateschitz visited Thailand, he went to the gentleman on the top right there and said, I like your product, which he'd seen was being drunk by lorry truck drivers coming down from Chiang Mai. He said, I like it. The Thai gentleman said, well, I don't know anything about the rest of the world. He had a small company, CP Pharmaceuticals, which was making these, and he said, let's do a deal. They put in about 200,000 US dollars each, took 49% each, and the Thai gentleman's son, unfortunately for him, took 2%, because he's now in London having killed somebody in his Ferrari, didn't he? And he's now living in London, I think. So 2% to the Thai gentleman's son. And then, when the Thai gentleman died, as a result of Mateschitz's brilliance, Mateschitz was worth 5.3 billion. This was a few years ago. And the Thai gentleman was the second wealthiest after Thaksin in Thailand. As a result of actually realizing that Mateschitz was a marketing genius. He didn't know anything about Thailand, but the Thai gentleman knew that he wasn't any good outside Thailand and needed Mateschitz. So this cooperation resulted in 49% of a lot as opposed to 100% of nothing if they'd kept it all to their respective selves. Thank you very much.
A very informative talk. I think lots of familiar brands, names, and stories. We're now going to do a little Q&A, and there's also refreshments at the back. Should anybody have any questions เดี๋ยวเราจะทำ Q&A เล็กๆเผื่อถ้าเกิดมีใครมีคำถามสำหรับเดวิดหรือว่าเราก็มี refreshments แล้วก็มี snack ข้างหลังเผื่อจะลุกขึ้นกินกาแฟหรืออะไรกันก่อน Any questions? I mean, maybe I have a question. So in our audience, we have quite a few creatives as filmmakers, artists, designers. Is there any specific pieces of advice you could offer?
Well, I suppose that the big issue is work with people you trust. Make your arrangements early on, before the potential has been seen, because once the potential's seen, then money rears its ugly head, and people with money like to keep as much as possible of that money, and you have disputes. So make your arrangements early on. Sometimes it's right to sell all your rights. Sometimes it's right to sell none of your rights and only license them. Sometimes it's a good idea to take a small shareholding in a company in the hope of getting something in the future. There is no one way of doing this, but what it needs you to do is realize that you need to collaborate in order to generate the best returns. You need to collaborate in order to move on to your next project. And so what I was saying there about selling, if you want to sell your design, fine. It may be you're the first few you have to just sell, then you might license, and you always need to create your own personal brand at the same time as well. Put a little C in a circle beside it in your name. Create a domain name with your name. Put that on all your documents and everything to create a personal identifier, I think, and to start creating the goodwill.
I'm a filmmaker, and I would like to know more about the licensing the film. Like, what could I reserve? Can I reserve the plot, or I have to reserve the copy of the film, or something like that?
With films, this is one of the good things about copyright, is there are many different types of copyright. So if you look at a film, there is, if you decide that you're going to use, let's take Harry Potter as an example. The book was licensed by J.K. Rowling to Bloomsbury Publishing. They brought out the book. Then Bloomsbury and she did a deal with Universal. There was then a script writer. The script writer owns a copyright in the script. And usually they will be paid for that, and they might have a small percentage. And then you have a separate copyright in the film. You have a separate copyright in the soundtrack. You might have registered trademarks in some of the characters, which you can then license for use on different types of products. So there are many different rights, and they can be dealt with differently. So you could license somebody to make your Hello Kitty bed linen or whatever it might be. So it depends on how you best finance it. Because, for example, I bought some TV characters of a children's TV show from the 1960s, which was very successful. Two pigs called Pinky and Perky. And we bought the rights because they were very old. So we bought those rights, and then we did a deal with the BBC. The BBC put in money to fund the development of CGI recreation of these. And we also got a French television company, and we sold the French television rights to them to get some money in, and the Swedish television rights. So we got all the money in to make it, and then we take a royalty every time it's shown.
So actually, you just like to make a deal with all the stakeholders, so no one make a problem in the law.
Correct.
Okay.
So you mentioned about trademark and copyright to use the C or the TM.
Yeah.
So let's say if someone goes ahead and infringes, do you still have the rights even though you didn't register, or?
Well, you see, this is. Well, no, you still have the possibility of suing them, but even though I'm a lawyer, I think that people are usually mad to sue people because it costs you money, and often you don't, and usually you don't get that money back. So what I always think is far better to try and create this image that you know what you're talking about, to keep them off your territory. But you can sue them, but the problem is it's expensive to sue, and often they don't have the money to pay towards the costs of your litigation. That's even disregarding whether they can pay you damages, and usually they can't pay damages, and often they just disappear and then set up again here. So I think suing people, unless you've got very deep pockets, is not a good business strategy, unfortunately.
But there's like companies that, I think specifically in China, that are set up to just,
There are.
to just accumulate these brands and register them in China.
There are.
And and I had a friend that went through this, and and she found out that her brand was already registered, and it took her 10 years to...
Yeah. And it will have cost her far more money to get it back than probably to, at the beginning, to have said to them, okay, I'll pay you 10,000 RMB, rather than paying 20,000 to a lawyer to eventually get it back. And I hate to say this, but usually it is far better to settle early on than to pay your lawyer to get what you think is yours. Because often pride is expensive.
Yeah. So a lot of times, related with negotiations, I mean, to make everything great for everybody who are related, or then just go in the court and fight each other.
Yeah.
Just a question about an example. I think the photographer passed away. Are contracts of this photograph transmitted his wife or his family?
Yeah, the copyright in photographs will, on the assumption they were not an employed photographer, if they were a freelance photographer, they would own copyright in the photographs, and that passes under their will, under their testamentary disposition, and whoever they have passed their property to by their will has the copyright for 70 years after that. Yeah, and you can go, or 50 years in some countries.
Because I know that you said different countries with different laws.
Yeah.
In Europe, it's well known that 50 years. In Thailand, for instance,
Yes.
especially for foreigners who work as freelance in Asia and follow the legal killing.
Yeah, but it would be a question if, for example, there was a copyright work which was created by a freelance photographer in Thailand, whether they were foreign or they were Thai, there would be automatically copyright for their life plus 50 years after that. Yeah. And you can acquire those copyrights, you can buy those copyrights just by a document in writing. So I happen to own a photo archive of the 1960s, so I own the copyright in the original photo session for the Rolling Stones and for Beatles, and we license high quality images from that photo archive.
How do you license the workflow?
Sorry?
The workflow. Can I make a license of my workflow of like filmmaking?
Process, like
Workflow, like the way if I have a team management, like I need like 5 people in my team, and each position is I assign to these people. I have like a manual of how we work together.
Well, that would be protected as a legal subject matter through the law of trade secrets. And so you should, when you have your manual, you should say confidential, not to be disclosed, and you could actually include that as part of a legal agreement, to the same as Kentucky Fried Chicken. If somebody takes a franchise of Kentucky Fried Chicken, they're given a thick manual how to make fried chicken, how to make hot wings, how to do everything exactly the same. And that's what you would be doing there, would be to use your trade secrets about the industry.
Yeah, it could be either in the form of writing or in the form of video.
Mentoring, or video, absolutely, yeah.
But if I am freelancer and I'm working on a commission project, and there is an agreement that the copyright will go to the company, it will go to the company.
Correct.
in Thailand, I believe the assignment is it's not automatic. It has to be assigned.
Yeah, we have to do right. Yes.
As in, like, it doesn't automatically, the employee's rights don't automatically.
Right.
So it's the reverse of the mechanism. Unless things have changed. There's any more questions on the floor, maybe what I suggest we do is have some refreshments. There, Jim Thompson, Eric Booth and Jim Thompson have kindly provided really wonderful snacks and coffee and herbal, herbal infusions. So I'd just like to thank everyone for being here. I know it's a public holiday, and I hope that you found the talk to be useful. I know that I did, seeing as I haven't practiced or ever practiced, but I'm interested in this area. So thank you so much for coming. Thank you, David, for being here and taking the time to share your knowledge with us. It's really great. Thank you. ขอบคุณมากเลยค่ะ